Welcome back to CCW Maine. Today we're going to be covering lesson number 4, the legal use of force. My name is Steve Dyer. I'm the owner of CCW Maine, and I am a certified firearms instructor through the United States Concealed Carry Association. This material is part of the United States Concealed Carry Association's program, and so let's get started with the legal use of force. So what we're going to be covering today, reasonable force. So if you remember in chapter 1, we talked about the reasonable person test. So we'll go back over that a little bit, dealing with the use of reasonable force. We're going to talk about deadly force and where reasonable force and deadly force overlap and when deadly force takes over. We're going to look at the use of force continuum. So the use of force continuum is a long-standing um, judge of where different uses of force can take place. And so we'll look at that. How will a prosecutor evaluate your case? And really, it comes down to what they can get 12 people in a jury to believe. So we'll talk a little bit about that. Um, at the end, we're going to talk about defense of the home and how that is different than defense of your person out in public. And then we'll talk about, at the end, we'll talk about defense of property. All right, so reasonable force and deadly force. So as you know, state laws dictate how use of force will take place and what that reasonableness standard looks like. So each state is going to be different. So I would highly recommend that you look at your state laws, see how they, what they say. But what we're going to go through today is we're just going to go through an overview of what reasonable force is and where deadly force would take over. So as you can see, there's an overlap there between the red and orange bars. Red bar being deadly force, the orange bar being reasonable force. The reason for the overlap is because at all times, the force has to be reasonable. So let's step back to our reasonable person test. That force has to be reasonable for the circumstances that exist at the time. So we have to have a reasonable fear of threat against yourself or a third person to be able to use force. Any force used has to be reasonable for the totality of the circumstances. And totality of the circumstances is the legal definition of the entire situation and how that entire situation looks to a third party. So if you look along that continuum, just below the bar where it says no force, it says retreating or de-escalating. So that's when you're using no force. So you have the ability to retreat, you have the ability to exit stage left, So get away if you have that ability. De-escalating techniques are great techniques for bringing down a suspect, bringing down a potential threat. That talking them down is an ideal way of dealing with a possible threat. Some of the other uses of force that aren't mentioned here are use of your voice and voice commands. Voice commands make great use of reasonable force, and they show a jury that you attempted to de-escalate or to bring the situation to a peaceful resolution. So exposing the firearm is a use of force that again must be explained as reasonable. So again, exposing that firearm, in some states you may be required to prove that there was an immediate threat against you for exposing that firearm. In some states that may not be the case. So we have case law here in the state of Maine that says that the displaying of a firearm is not the use of deadly force, not the display of deadly force. It is simply the use of force. So pointing a firearm at another person is when you get to the deadly force range in most states. And obviously, shooting at someone would definitely be in that deadly force range. Shooting and killing someone, um, again, is going to be different. But deadly force may be used when there is an immediate and unavoidable danger of death or great or grave bodily harm to an innocent person, where no other option exists other than the use of deadly force. And so this is what we're going to be going through today. These are the elements of the crime that we're going to be looking at, which is what a prosecutor is going to be looking at to determine if the use of deadly force was justified in the situation. And we'll take you through a few situations, a few examples to give you um, some ammunition to be able to chew on. So the rules governing the use of deadly force outside the home, so there must be an immediate fear of death or great grave bodily harm to yourself or a third party. The threat must be immediate, so it can't be in the future. It has to be an immediate threat. And it must be so serious that a reasonable person would have also feared death or grave or great bodily harm in the same circumstances. So that's what we're going to be looking at. That that's the immediate fear of death. You also have to prove that you're an innocent party. So we'll talk about what an innocent party is. You can't be seen as a person who started or escalated a situation. No lesser force is sufficient or available to stop the threat. So in a lot of cases, you'll see where a lesser um, um, option might have been available to the person. And if that lesser option could have been deployed and wasn't, now we have to explain why that either wasn't done or shouldn't have been done. And there must be no reasonable means of retreat or escape. So again, we're talking about, in general, the use of deadly force. You must retreat or escape if you have that option. So let's look at a couple of scenarios here. So reasonable or immediate fear of death or great or grave bodily harm for the yourself or a third party. So what this usually means to pass the reasonable person test is that the prosecutor and or the jury would also believe um, that a reasonable person would have done apartment complex. So you live there. You notice a neighbor standing on his third floor balcony. You exit your vehicle and head toward the front door of your first floor apartment. Leaning over his balcony, your neighbor, who has threatened you in the past, pulls a knife from his waistband and shouts, "You're a dead man." Fearing death or great bodily harm, you shoot your neighbor. What do you think? Was it reasonable or not? So you could claim that you did fear great bodily harm or death, but you'd fail on the immediacy portion of the rule. So your neighbor was on the third floor balcony. The likelihood is he's not going to be able to get to you with a knife unless you know him to be a professional knife thrower. Your immediacy has probably gone by the wayside there. So you need to either drive off and come back, or go into your apartment and avoid the situation. Again, exit stage left. All right, the next scenario. So after entering a bar, another individual steps on your toe. You mutter asshole under your breath. The individual bumps into your shoulder, knocking you back. You shove the individual to the floor. The individual jumps up from the floor and charges you with a knife. you pull out your concealed handgun and shoot the knife-wielding attacker. What do you think on this one? That's a pretty interesting one. So, as simple as this error was, you failed on the innocent party rule. Okay. While not as significant as throwing a punch, you've just stepped over the line from the innocent party to an active participant by swearing at the individual. So if the George Zimmerman case in Florida, when George Zimmerman shot Trayvon Martin, if you watched any of the proceedings of that case, you'll remember that the whole first day the prosecutor spent on the language used by George Zimmerman. Language has meaning, and it does to juries. So you got to be careful what you say in situations. So that's one place where you would have stepped over the line, but you shoved the individual to the floor, again, breaking the innocent party rule. Okay, so you didn't de escalate, you escalated the situation, which again violates that innocent party rule. And at this point, you're in immediate risk of death or great bodily harm. But since you've broken rule number 2, you should expect to be charged with a crime. Now, does that mean that you wouldn't use your concealed handgun to shoot the knife wielding attacker? That's up to you. You've got to make that decision. Um, that's something that only you can make, but just know that you probably will be charged with a crime in that case. All right, the third scenario. You leave a busy city street and turn down an alley to take a shortcut to your car. Okay, so we discussed this in an earlier chapter. Why are you walking down the dark alley when you can walk on a perfectly good, well-lit street? But anyway, an individual approximately half your size steps from behind a dumpster and pulls his shirt aside while reaching for a semi-automatic tucked into his waistband. You shout, "Don't hurt me," and draw your firearm from the holster. You leave your pepper spray in your pocket. The individual draws his firearm from his waistband and elevates it in an effort to shoot you. You fire 2 rounds at him, and one strikes him in the shoulder. He immediately drops his firearm and it slides under the dumpster. Bleeding, the individual stumbles toward you. The individual refuses your further commands to stay back, and he steps into what you consider to be your danger zone, so you shoot him again. All right, so we're going to take this piece by piece, and if you look at it at this point, so your first mistake, while you haven't broken one of the rules yet, you've put yourself in a risky situation that you could have avoided if you'd stayed with the crowds. Just like we said earlier, if you can avoid going down back alleys where you're going to be by yourself, if you can be in amongst people, you're in a much better position to not be the victim of a crime. So at this point, you would probably get most prosecutors to agree that you had no alternative other than to immediately resort to force when the person pulled the semi-automatic firearm. You would have been justified, most likely, to shoot your firearm, pull your firearm and shoot it in defense of yourself. Even though the guy's smaller than you, that doesn't really matter. The gun kind of equalizes everything. And so at that point, you would probably be justified in your shoot. However, the scenario continued, and the gun that the suspect had slides under the dumpster. At that point, he's no longer armed. So what this tells you is you may have been justified at one point, but you may not be justified at a later point. So timing is everything. And so at this point, he's coming back into your danger zone, but he's no longer armed. So therefore, you no longer have the ability to use deadly force. You can use force still. You can use the amount of force necessary to stop the threat, but by stopping the threat, he's not threatening you with immediate death or serious bodily injury. So deadly force can't be used. You can still use the amount of reasonable force necessary. And the final scenario that we're going to go over today, on your way home from work, a dog runs in front of your car on the freeway. You slam on your brakes and are rear-ended. Your car is fine, so you continue on until you can pull onto the shoulder. But the other car is out of commission and pulls over several hundred feet behind you. The other individual jumps out of his car with a machete and charges your vehicle, screaming that he's going to kill you. You exit your vehicle and take up a position behind your driver's door. You shout commands continuously for the 40 seconds it takes the other individual to reach you. In the end, you shoot the individual as he gets within 21 feet of you, because we all know the 21-foot rule. And so, is that a justified shoot? Well, I think we're going to find out that at that point, first of all, you could have done so many things along this scenario. So at that point, you are in immediate risk of death and great bodily injury, but you had plenty of time to drive off during the 40 seconds that you waited while you were taking cover behind your vehicle. You could have driven off. If you remember back in, I think it was chapter 1, we were talking about what do you do in case of an accident? In case of an accident, you stay in your vehicle and you wait until the police arrive. Well, here we see, you know, you may change that because as you're sitting in your vehicle, you see the guy get out of his car several hundred feet behind you and come at you with a machete. I'm taking off at that point, and that should have been what you did here. So again, we talked about the reasonable person test and what a prosecutor is looking for, and the prosecutor is really looking for what can the prosecutor get 12 jury members to believe. And so we also talked back in chapter 1 about the jury members that you're going to have. So this is a typical jury. And do you see many people there who might be concealed carry permit holders or lifetime members of the USCCA or NRA? Maybe. The likelihood is you're not going to get 12 of them. So is it really a jury of your peers? Well, that depends on how you define jury of your peers. But this is likely to be the jury that you receive. And so these are the people that you're going to have to convince that what you did was reasonable based on the totality of the circumstances, everything that was going on, that you acted in a reasonable manner that any other person would have done under the similar circumstances. All right, so we've been talking about deadly force and use of force outside of the home. Let's talk about use of deadly force in your home, and specifically as it relates to, I'm sure you've heard of the castle doctrine. So the castle doctrine doesn't exist in all states, just like other laws, it is state specific. And so the different tests will apply depending on which state you're in. So in this case, if an intruder is in your home, do not attempt to locate him. Okay. We're not the police. We're not out to find the bad guy. We're out to protect our family. That should be our first line of defense. Is we talked about having a plan in chapter 1. We should be executing that plan, in this case, when we're at home, your family members should all know what that plan is, and they should be on board with you helping to execute that plan that you've put in place. And that plan will involve everyone getting together in one location, most likely, depending on the setup of your house, and then you defending that location. So in my case, I live on a single story home, and the bed I have my wife and I have our bedroom, and my kids' bedrooms are across the hall. So my daughter knows to go to my son's bedroom, and my daughter and son will then come over to our bedroom, at which time I can defend that one room. That one door is all I have to defend. So that's the normal scenario that we have put in place, and my family knows that, and they know what to do in case of an emergency. And all this came out of Sir Edward Coke, which was actually Sir Edward Cook back in the day. But he came up with this foundation of the castle doctrine, and he wrote that an Englishman's home is his castle, and therefore there was a right to defend that. He also was the originator of what we have as our Fifth Amendment, which came out obviously a couple of centuries later, but where the Miranda warnings came out of. So again, against the right against self-incrimination. All right, so finally, using force to defend property. So using force to defend property is one thing that you can use some force to defend property in most states, but they're not going to allow the state isn't going to allow you to use deadly force to protect property. Now, obviously, this all changes from scenario to scenario. So if we're looking at this car and this guy's breaking into the car and my kids are inside, that changes everything, because now I'm not defending property, I'm defending life. But let's just assume that this is just my car and that this guy's breaking into it. So if that's the case, I can't use deadly force to stop that scenario. What am I going to do if I come upon this situation? Well, in all likelihood, I'm not going to get this close. I'm not going to get that close to a guy breaking into my car. I'm going to be on the phone with 911 as soon as I see him, and I'm going to be looking for a place to um, seek cover. I'm going to be, so this looks like a parking lot, parking garage. And so I'm looking for a cement pillar to stand behind and keep an eye on this guy while I have 911 on the phone. That's my recommendation in this particular scenario. And so we look at, when we're looking at personal property, I look at this like the Shark Tank analogy, and so this actually reminded me of a time that I took my family to SeaWorld, and so my son, who was like 2 or 3 years old, ran down to the shark's tank, and I was scared to death. And as I got down to the shark's tank, my son was standing there at the edge. He was perfectly fine. But the scenario is, if I dropped my Rolex into the shark tank, am I going to jump in and grab that Rolex? Absolutely not. Um, I'm just not going to do it. But if my son had gone over the edge and jumped into that shark tank, do you think I'd have gone in to save him? Absolutely. That's the difference between life and property. I will I will use my life to defend another life, but I'm not going to use my life or lose my life to defend property, but I will to defend another person or myself. So we've gone over reasonable force, we've gone over deadly force, we've gone over the use of force continuum. How will a prosecutor evaluate your case? We talked about that. We talked about defense of the home, so the castle doctrine, and we talked about defense of property. So each one of these things are important. They all must be recognized, and I hope that you come back for lesson 4. And again, my name is Steve Dyer with the United States Concealed Carry Association. I am the owner of CCW Maine here in Maine, and I would love to hear from you. Thank you very much and have a blessed day.